Inec was not the party that went to court. Sometime in September last year, on the 2nd of September 2025, one Honorable Balagombe took Inec to court alongside Senator David Mark and his Secretary General and his group. Inec was joined. Now, on that second, the plaintiff filed the originating summons and also a motion ex parte with a motion on notice. Now, the motion ex parte was moved on the 4th day of September 2025, wherein the trial court, Justice Emeka Nwite, directed that the plaintiff should give notice of the ex parte motion to the respondents, that is to the David Mark Group and Inec, for them to show cause why the motion should not be granted. Now, the parties were expected to file counter affidavit and show cause why the application should be refused. So they did. But at the same time, the Senator David Mark decided to go on appeal. So when he filed the appeal, sometime on the 18th of September 2025, the appeal lasted until the 12th of March this year, which is about 5 months. And the Court of Appeal not only dismissed the appeal, it was an interlocutory appeal. They dismissed the appeal and at the same time made some preservatory orders. And the preservatory orders were very clear, to the extent that, number one, in view of the fact that Inec had already released its timetable for the election, that the trial judge was directed an order to proceed with the case expeditiously. That is, the court granted accelerated hearing. And this is an originating summons, which ordinarily can be decided within some few days, some few weeks. That is number one. Then number two, which is now causing the controversy, is the order, specific order, that parties should maintain status quo ante bellum. I did not just stop at that. The parties should not do anything that will force a fait accompli on the trial court. And finally, that parties should not do anything that will render the proceedings before the court nugatory. Those were the definite orders of the Court of Appeal. Now, when I first heard of it, because it was delivered on the 12th, I heard of it on the news, social media. And before I knew it, people were calling me that Inec has the David Mark name group has been ordered to be removed. I said I cannot act on social media news information. I read it on the social media. Then I look at it, it was an interlocutory appeal that has been dismissed. So ordinarily, we should be talking of going for the substantive trial. Then on the 16th day of March 2026, I received 2 letters. One from the solicitors of Senator David Mark's group, requesting me to maintain the status quo at the Federal High Court and not to recognize the other camp led by Nafiu Bala. And on that same day, I also received another letter from Summit Chambers, the solicitors to Nafiu Bala, that by order of the court, he was supposed to be recognized as the leader, national leader of ADC. I requesting that I should comply with the order. So naturally, when you receive such communications, you have to refer it for advice. I call a meeting of the legal department and the EPM, and we look at the facts based on the judgment. And the EPM specifically requested that since there was going to be a meeting of the political parties, what do we do in this circumstance? And secondly, that they had received notice of the meeting of Inec of ADC by David Mark's group. So looking on the face of the judgment, and then I felt, okay, what you should do in the circumstance, we are just receiving this case. Invite them. Go ahead, invite them, monitor whatever. As soon as I did that, I got another letter from Summit Chambers on the 27th day of March 2026. And that letter specifically drew my attention to another motion ex parte, an emotional notice filed on the 15th day of December 2025. Now, in that ex parte application, they were asking for an order restraining David Mark and his group from parading themselves as the leaders of the party. And secondly, restraining Inec from monitoring any of the meetings or recognizing whatever that comes out of the meeting. So this was a proceeding that was filed on the 15th day of December before the judgment of the Court of Appeal. And so they were alleging that, given the fact that they had already brought the notice of the Court of Appeal judgment to me, I still proceeded to ask that EPM should monitor their next meeting, that I was in violation of that judgment. And also for inviting them for the meeting of the political parties was also a violation of the judgment of the Court of Appeal. At that stage, I now had to call for the file so that to be abreast of the fact fully, and then went through the judgment and also look at it, the order, the nature of the order granted by the Court of Appeal. Now, first and foremost, the Court of Appeal stated clearly and ordered that status quo ante bellum must be maintained.
Which is a problem.
Which is, well,
because at the press conference, yes, Senator David Mark said that you took sides because it was not for you or Inec to interpret what status quo ante bellum means. That you should have gone to the Court of Appeal to seek an interpretation instead of imposing an interpretation, because, as he said, that nephew Gumbe has no local standing in the matter, having resigned from the party on the 18th of May, which was communicated to INEC, and which was a letter INEC acknowledged. And on the basis of that, he was saying that, look, INEC has become a threat to democracy. In fact, the spokesperson of the party, Bolaji Abdullahi, Malam Bolaji Abdullahi, in fact, went further on the morning show earlier to say that INEC has become a criminal organization and they will not agree.
Well, that is unfortunate if INEC is being described in that form.
I'm quoting,
but the truth of the matter is that after the Court of Appeal judgment, I received another letter from David Mark's group informing us of the rescheduling of the election activities for the primaries. And now, when I look at the motion that was already pending before the Federal High Court, that INEC should not monitor any meeting, congress, or convention. So, if you go back to the order of the Court of Appeal, and that was the major concern, if you go back to the order, none of the parties should do anything that will foist a situation of fait accompli on the court. So it means that so long as that motion is pending, if you say somebody does not have local standard, it's already gone to the court. So you have to wait. You can't just assume. You have to wait for the court to decide whether and that is part of what the Court of Appeal was saying. Let the court decide the rights and the responsibilities of the parties. So when they gave that notice to go ahead with the Congress and convention, I said that will be breaching that part of the order of the Court of Appeal that says none of the parties should do anything that will foist a fait accompli on the trial court in respect of the subject matter. And that is part of the relief they are claiming in their originating motion summons. And that is also what they are claiming in their motion ex parte and the interlocutory motion, notice or motion or notice. So given the fact that they are informing me that they are going to hold their Congress, I think on the 9th of April.
Yes.
And the Court of Appeal said, don't do anything that will affect the subject matter of the pending case in the Federal High Court until it is decided. Now, at that stage, we felt it would be necessary to look at the complaint of all the parties. The letter written by the council, and then the letter written by them calling for us resettling their Congress. So it was at that stage that we decided to meet and look at the facts, the circumstances, what is status quo antebellum. So if they are saying that we've taken side, that is not true. Because if you look at status quo antebellum, we try to interrogate it. And it naturally means that the status before the hostility started. And in some cases, there are several authorities that says the status before the war. And the status when things were peaceful, the peaceful conduct until the controversy came. So if you look at it from that perspective, and there are Supreme Court decisions to that effect, that when status quo is even different from status quo antebellum. So when you talk of status quo antebellum, it means I have to go back. And that was the specific order of the Court of Appeal.
There is an indication of time here.
Yes.
When you say status quo antebellum.
Yes.
At what point will you put the date of that status quo? Will it be before the resignation of Nafi Bala Gombe from his position, deputy national, or will it be from the point at which Ralph Uke-Nwosu ratified the National Working Executive Committee led by Senator David Mark?
Okay, the issue of the resignation, the validity of it or not, is pending before the Federal High Court. So the Federal High Court has to make a pronouncement. That is why you cannot really say, I know, I have the record. We have record of a letter written by ADC sometime ago, I think last year, informing the commission that Nafi Bala had resigned.
That was in August.
That was in August, thank you. Then the Nafi Rabiu also wrote and is contending before the court that he did not resign. And as a matter of fact, that his signature was forged. So this is a matter the court has to decide. So it's not a matter anybody can act on now. And that was why we were very careful when his lawyer was insisting that given the fact that he did not resign, and by virtue of the provisions of the Constitution of ADC, as the Deputy National Vice Chairman, when all the other members resign, of the ESCO resign, that naturally he ought to be the national chairman of ADC. But looking at the fact that it's a matter the court has to decide, we decided that we're not going to touch that part. And then looking at status quo antebellum, given the meaning, the definition of given to it by Supreme Court, that it means before hostility, when things were still peaceful and there was cordiality until the controversy. So if you look at it backwards now, you look at it from the viewpoint of when was there a controversy. Controversy started when on the 29th day of July 2025, there was a meeting of Inec, which now ratify the appointment of David Mark's group. So that is why you had issues. So if you look at antebellum, meaning that before that time, what was the position? Now, in this case, the plaintiff went to court on the 2nd of September, 2025. He filed their motions, motion ex parte, motion on notice for injunction, and also filed further motions ex parte on the 15th of December and motion on notice, restraining us and even stopping them from parading themselves. Those are proceeding. Court of Appeal said, don't do anything that will render any proceeding, whether it is valid, whether it is competent or not, so long as it is fair. Don't do anything that will render the proceeding nugatory.
Okay.
So if we are going to take any step to go and monitor any primaries now, there's an injunction that stops us from going there. To go and monitor any Congress, there's an injunction that is stopping us from going there.
Okay. The leadership of the ADC, that's the David Mark group,
yes,
they've now issued a statement of defiance that all those declarations by Inec that they would not obey any one of them because Inec has no powers to choose the leadership of a political party, and that they will go ahead with their Congress, they will go ahead with their convention, because also they have to be part of the forthcoming elections in Ekiti and Ondo. So what will be the implications?
Well, as far as we are concerned, Inec is a party in the case. And Inec was sued as a defendant by a member of ADC. That is number one. Then secondly, you see, the court is very clear that parties, including David Mark himself, should refrain from doing anything that will foist a situation of fait accompli on the court. So if they are going ahead with their Congress, with their convention, it is left for them to look at it, whether it is in contravention of the court of... INEC did not just take a decision. We didn't just wake up one day and took this decision. There was something led to it. There was an order of court. Don't do anything. Don't take any step that will render any proceeding before the court nugatory. And also that will force on the court of appeal on the trial court, a situation of helplessness, of fait accompli. So if already they're asking that don't do any Congress, don't do any convention, it's a relief that is being claimed. And especially they file a motion for that purpose. That motion has not been determined. So if they decide, let me tell you what happened in Zamfara. It happened in the past. We don't want to conduct an election without this early warning. And at the end of the day, after you have won, the court again will come and declare the election invalid. And the implication is that the person with the second highest number of votes will be declared the winner. It happened in Plateau State during the last election, where after the question of primaries was even an issue, and congresses were not held in some states, in some portion of Plateau State. So the court said, go and do those primaries. But unfortunately, they did not obey the court order. So failure to obey the court order has consequences. They are at liberty to do whatever they want to do. But INEC could not want to go into a situation again where there's another, don't do anything, don't take any step. I have the judgment here. I can read it to you. It's very definite. So if I proceed, for instance, to monitor their convention, it means that I'm taking steps that is going to affect the subject matter that is pending before the court.
Okay. How about this accusation that INEC is being used under your leadership to create a one-party state, to leave Nigerians with no other option but President Bola Ahmed Tinubu in 2027? And it's not only the ADC that is saying that. Professor Pachutome, to be specific, has also said that by recognizing the weaker faction in the People's Democratic Party, there is clear evidence that the INEC chairman is working for President Tinubu's one-party rule, one-man rule. In fact, I think the ADC people, they use the word dictatorship. Are you guilty as charged?
I am not guilty as charged, Ruben. Let me say it very clearly. I am not a party to the plan of anyone to turn Nigeria into a one-party state. By the Constitution of Federal Republic of Nigeria, Nigeria is a multi-party state. And this is recognized by the Constitution and the Electoral Act. Look at the last FCT area council election. There were many parties that contested. I think about 10 political parties. And in that case, you even had the ADC having 5 and PDP winning 1. Zenith Labour Party did very well. There are other parties that are existing. But you see, one of the challenges we've had is this issue of party leadership. And it's something that is impacting on democracy. Because if those issues are not addressed on time, then it can cause a lot of problems. So in this particular case, let me take you back to the judgment. Nobody is looking at that part that ordered the trial court to give it expeditious trial. This is an originating summons. and originating summons that, in fact, this judgment is up to 2-3 weeks now, and originating summons that could, if they had gone to court, would have been decided by now, because the Court of Appeal has given a specific order that it should be decided expeditiously in view of the timetable that we have issued. So given the fact that the parties are in court, one party, whether it has local standard or not, talking of Nafi Gombe, he's alleging that he's the authentic chairman of ADC. And the David Mark Group is also alleging that they are the authentic leader of that, his group of ADC. So the best in the situation is what the Court of Appeal said. Go back to the court, hear them on time, and decide the matter. While you are doing that, no other party should do anything. So therefore calls to question the fact that this order has been made. They're supposed to go back to the Federal High Court and let the Federal High Court, with that order of Court of Appeal is enough to compel the judge to hear that case expeditiously. So the whole idea that Inec is being used to turn Nigeria into a one-party state, like I said, if this judgment did not come, did I just decide on my own? And the Court of Appeal did not just dismiss the appeal. He said they are making preservatory order. And in the preservatory order that status quo antebellum, not just status quo antebellum, before hostility, should be maintained. So what the commission did was just I have the record. I went to the record. Before 2nd of September 2025, when this matter was filed, what were the positions of the parties? And then let the position of the parties be resorted to. So if they want to go ahead with their Congress, they have to look at it vis-a-vis the order of the court. And then if at the end of the day, the court gives them judgment, so be it. And then they go on, life goes on.
Okay, there are other complaints by the opposition parties. Like, for example, the voters' revalidation exercise, which requires people to bring their NIN, and then also, yes, NIN, I think that's the case, and then updating of the National Voters Register also. Now, the opposition parties are saying that this is a plan to disenfranchise many Nigerians, considering the time that is available for that exercise, and then the stringent requirement of NIN, when there are many people in rural areas and underserved parts of the community that have no NIN.
Okay, the decision to revalidate the voters register was taken even before I became the Inec chairman. The only problem why it has not been implemented is because it was not in the budget. So that is why Inec now decided to put it in this year's budget so that the exercise could be carried out. Our records for now, if you not adding the number that have registered recently, we have about 93 million voters. That record is inaccurate. And for every election, that is how you judge the performance of the election. Let me give you an example. In Anambra State, when we had the governorship election last year, there were about 2.8 million registered voters. And out of the 2.8 million registered voters, only about less than 600,000 turned up for registration. But there and then, our attention were drawn to certain facts. People were coming to me, they knew of many people on that register that died many years ago. There were so many people that are registered several times. Have you even thought of it before the card reader was introduced in the year 2000? Elections in Nigeria, you're always having 80%, 90% of voters turn out. But the moment you introduce electronic accreditation, whereby it's not a situation where you can just go and collect ballot papers and vote, then you started having this issue of reduction in the number of register. So the 93 million we're talking about is not realistic. And that is the measure locally and internationally to decide whether our election is credible or not. Oh, voter apathy, the turnout is very low. Now, revalidation is going to be done in phases. You have the first phase, which has to do with the framework, and then engagement with the stakeholders. That is the first phase. Then you have the second phase, which has to do with going to the field. It has to do with testing and so many other things. Then before the actual exercise, before you do data, another thing. So what we have talking about is even let's have the state framework. We have done the framework. Let's engage with the stakeholders. And then we see how far we can push this process. At a meeting early this year with all the recs, we look at it and how it's going to be done. And we all agree that it's a very good exercise. Now, I have received complaint that because of the time, as a matter of fact, during our last meeting, that matter came up. And we said, we're still going to engage stakeholders. Next week, we have called all the recs for a meeting and some critical stakeholders. So that we look.
Same resident electoral commissioners that ADC is saying should be sacked and you two should resign.
No,
or you two should be sacked along
with them.
Are they
talking of recs or national commissioners?
Okay.
I'm talking of
mention commissioner.
I'm talking of resident electoral commissioners.
They say they don't need the service.
Well, you see, the problem we have in Nigeria is politics of power and not politics of the people. And as long as we don't engage the people, everybody, as I'm speaking here, I have a vested interest in Inec, isn't it? So when they speak, they have their own vested interest. There are other vested interests. Even social media, if you look at people that talk, they talk on the prism of their own interest. So this question of whether they lack confidence in what Inec has done, Inec did not take the decision that is causing these grievances.